So, so we are moving to our next presentation, which is another very interesting topic, setting up manufacturing units by Japanese corporations. According to a study report from Asian Community News Network, the number of Japanese companies in India dropped marginally to 1,439 in 2021 from 1,455 in 2020. However, it is also mentions that the number of Japanese companies in India is expected to grow further in the coming years. To discuss setting up manufacturing units by Japanese collaborations in India, I would like to call Mr. Rohan Singh and Mr. Sushant Shetty. Let me briefly introduce him. Mr. Rohan is a partner in the corporate practice with significant experience in a wide range of corporate transactions, including mergers and acquisitions, private equity, venture capital, joint ventures, and corporate restructuring. His practice focuses on cross-border and domestic merger and acquisitions, amalgamation, joint ventures, strategic alliances, acquisition, investment, and divestitures. He has worked with leading domestic and foreign corporations, sovereign wealth funds, private equity investors, financial sponsors, governmental institutions, and ventures capital funds in complex transactions in a range of industry sectors, including financial services, information technology, e-commerce and retail, manufacturing, fintech, insurance and real estate, IT parks, residential and educational infrastructure. Mr. Sushant is a partner in the Mumbai office of Fox Mandal and heads the real estate and infrastructure practice of the firm for the Western India region. Sushant regularly advises domestic and foreign clients on due diligence, investment and acquisitions in real estate property, with a strong focus on commercial leases, manufacturing facilities, warehousing, renewable energy projects, and data center advisory. His clients include global fund houses, multinational corporations, property developers, property owners, local and international investors, statutory boards, bank and financial institutions. So I would request Mr. Rohan and Mr. Sushant to please come on stage.
Good afternoon, ladies and gentlemen. My colleague Rohan and I would be covering our session on legal aspects of setting up manufacturing corporations, manufacturing units by Japanese corporations. So I'll start with topic number one. So before I start, I'd just like to brush up on the categories of land parcels that we have. First would be the private industrial land. This could be either freehold or leasehold. Basically, this is non-government land owned by private individuals, which could be individual persons, it could be corporations, it could be partnerships, which are not government owned or affiliated. So the documentation, of course, would vary at large depending on the ownership structure of these entities. Secondly, we have government industrial lands and schemes. Of course, this is more relevant to this whole conversation, because Japanese corporations and most MNCs prefer government-owned lands for various reasons, apart from the clear title that they offer. First would be MIDC, which is the Maharashtra Industrial Development Corporation, which is, of course, here in Maharashtra. Then you have the IIA scheme, which is also here in Maharashtra. Then you have similar schemes and landowning authorities in the rest of India, like you have the GIDC in Gujarat. Then you have the KIDB in Karnataka. Of course, the third, the most popular, is the Japanese industrial townships. So Japan is the only country which has its own dedicated township. There's no other country who has that in India. So that is a sort of a testament to the Indo Japan ties and the way the Indian government wants to promote Japanese industries. Of course, I wouldn't go much in detail into it because my friends on the consulate and JETRO will of course be able to cover more of these aspects of the JITs as far as trade is concerned. But I can just tell you that these JITs offer a lot of schemes like stamp duty exemption, electricity duty exemption to make it more favorable. They also have a Japanese desk, translation desk. So it's more or less like the same industrial townships, but with a hint more help towards the Japanese and to make it more Japan friendly. So to come to the main session of the topic would be the due diligence part of it. So I'll just, so suppose if you are entering into India, or a Japanese company, you want to set up your manufacturing unit in India, of course you will go to some lawyer, you'll go to me, you'll go to some any other law firm who does this. But the due diligence process you should be knowing, even though the lawyer will cover it for you. So this is, I'll just give a hint of the process that we generally follow. First would be the review of the title documents. So depending on the ownership structure, like I mentioned, you'll have different types of title documents. So if it's a leasehold, you'll have a lease deed to review. If it's an it's a private freehold, you'll have a sale deed to review. If it's a statutory authority like MIDC, they have their own formats of leases. So if it's an allotment scheme or if it's an assignment of an MIDC, then you have more freedom to do documentation. So what do we check when we do title? As a lawyer, what do I check when I do review of title documents? One is of course the chain of title. Land over here in Maharashtra, especially, I can tell you, especially closer to the Pune and the Navi Mumbai belt, land is very scarce, frankly. So you have a lot of fragmented parcels. They're owned by farmers. So it's not like you get clear title unless you take governmental land. So even if you go under the IIA scheme, you may end up taking a land which has a lot of legacy issues. But that's where your lawyers or other consultants come in. You go to your industrial consultants like JLL, CBRE, Cushman, who will of course advise you on the good parcel of land depending on the risk appetite. So you see, like I said, chain of title, you see the stamp duty has been paid. That's what you come to know with the review of title documents. Then you have the review of revenue documents. So revenue records, in fact, in Maharashtra, it is, I can give an illustration. Since we are in Pune, I can take the illustration of Maharashtra is your property card or your 712 extract, which is sort of, shows the owner of the property. But of course, I'd like to clarify at this point, there are many Supreme Court judicial precedents that say that the 712 extract or any property card does not confer ownership title on the landowner. More or less, it just gives you the person who's paying the land revenue, which is construed to be the owner. So that is where it is. There's a lot of confusion that Saat Bara mein mera naam hai. I know my name is on the Saat Bara, so I am the owner. So that is, of course, not the case. Then you have your mutation entries, which show each time there's been a transfer or any encumbrance created on that land. That is something we look for. So, like I said, I'm explaining the process, but do hire a lawyer when you do this. Not me, but anyone else. And please feel free. Then consent for mortgage from authority. So suppose you are taking MIDC land. So even though you are creating the mortgage, the land is still owned by MIDC. So you need to take consent of MIDC when you proceed with it. And and not only consent, MIDC also insists on a tripartite deed. So you have to make them a party as well to such a mortgage document. Then you have searches at the land registry. This, I'm sure from a Japanese friends, this would be very, we have something in common here. India and Japan both follow the deeds registration system. Like in Japan, you have the deeds title documents flow. So the state doesn't certify title. So we follow the same system in India. Even in Japan, you have the land registries who are just repositories of the title documents, and not the state doesn't really certify the title as such. That's the same system we follow. So we have to get searches done at the local land registry, and we generally get it done for a period of 30 years for various complex legal reasons, which I wouldn't want to go in right now. But 30 years is the general term that we go for. But if we think that the root of title is say 50 years, we can go back to up to 50 years to check the title flow. So that's how we do searches over here. There's a land registry and a person visits it. It could be the lawyer, or it could be you have professional search clerks who get this done. Then you have litigation searches. So anyone who's done business in India knows litigation in India is a never-ending process. It's one of the most cumbersome processes around the world, not scaring any Japanese investors, but that is the case. When you face litigation in India, you may be in your college, and when it ends, you may be, at your retirement party. So that's how litigation is. So it's very important to know this when you're acquiring huge parcels of land, especially when it's fragmented land, because if there's a parcel right in the middle which has a litigation, then your whole land is basically useless. It's not like, you can come by helicopter or something. So you need to ensure that all the land parcels have no litigation on it. And especially, of course, if it's an MNC, it's more difficult to settle litigation. So how do we find out litigation? One is, of course, we ask the landowner. he may or may not give us the details, then you can do searches. Searches are entity based. There are a lot of software tech companies who do that. We work with them. They provide you details of all the litigation on that particular land parcel based on entity name. It's not a foolproof process, because sometimes if it's individual, you put the spelling of the person, and you may have 100 persons with the name spelling. Companies bit easier because it works on the SIN number, which is, of course, everyone can't have the same SIN number. Then you have your ROC search. So if it's a company, you have a registrar of companies here, you can do search with them, and then you can come to know whether there is any, sort of mortgage or charges or registered encumbrances with the ROC. This is in case of a private limited company. And you have the CERSAI search. So this is a relatively newer concept. We follow this. So you have the central registry for securitization. So they maintain the list of mortgages created bank-wise. You have an asset-based and a database search. The database search gives you how much that particular debtor, how much mortgages he has, and the asset-based gives you on that particular property how much mortgage is there. So that is something we do as a value addition. Then you have your basics, approvals and permissions. So if you're taking a land with structure, you'll see if your structure has a BCC or an occupancy certificate. And of course, if it's an agricultural land, it was an agricultural land, you'll check for the NA certificate. Then you have the public notice. I'm sure when you read the newspaper every day, you must be coming across some public notice that someone is interested to buy some land. So what is the purpose of that? People say that if I issue public notice, does that mean nobody can come after me afterwards? That's really not the case. It just shows you as a bona fide purchaser. So in Maharashtra, we generally issue in the name of one English newspaper and maybe a Marathi newspaper. In other states, depending on the local language, one English, suppose you're in Gujarat, you would take the other one in the Gujarat newspaper. Then I come to my last topic, inspection of original documents. So earlier you could create an equitable mortgage by just depositing the title deeds with the bank. So it's very important to inspect the documents, which the lawyer does. The lawyer inspects the documents one by one, and then he sees whether all the original documents are there with the vendor to check whether he's not mortgaged it, because after he sells it, he may go somewhere and you may end up with the mortgage to deal with. So that is something we look at. So since time is short, we would be we can answer any Q&A you may have. Me and my colleague would be more than happy to answer it during the networking tea break. So this is just a general process. You can get in touch with us if you want to know the more detailed process. I'll pass on the mic to my colleague Rohan Singh, who will take you through the corporate aspects of setting up of Japanese companies in India. Thank you.
Hi, good afternoon, everyone. So the short topic that I'll be covering in the next about 5 to 10 minutes will be a brief look at what Japanese investors perhaps need to think about when they're looking at incorporating companies in India. That's just my background. The two key things or the key sort of sets of laws that Japanese investors as well as all other type of foreign investors need to look at when they're incorporating in India or setting up in India is one, compliances from the Companies Act perspective. That is the law which regulates corporations set up and incorporated in India. And secondly, India does not have full capital account convertibility like certain countries do, which essentially means that you have to comply with the Indian foreign exchange regulations, which are administered both by the Ministry of Financial Services of the central government and the Reserve Bank of India by way of issuing rules and regulations under India's Foreign Exchange Management Act. We'll briefly cover some of these aspects, and as my colleague Sushant said, if there's any specific questions, we'll be happy to address them in the coffee session following here. So just going to the Companies Act perspective, the first question a foreign investor should really ask is whether they're looking to set up a private company or a public company. Private company obviously is easier to operate, the requirements are lower. For example, you can set up a private company with just 2 shareholders and 2 directors. So it's a relatively less compliance. A public company, you will need 3 directors and up to 7 shareholders. And those are just the basic distinctions. There's obviously more distinctions which we can discuss separately between a public and private company. Now, there are certain sectors in India when you set up companies, those particular sectoral regulations require you to actually be a public company rather than a private company. So an example for that is the insurance sector, because the Insurance Act that the Indian government, Indian Parliament has made requires insurance companies to be public companies rather than private companies. So there you won't have the discretion on what sort of a company you want to choose. But generally speaking, we've seen foreign investors, including Japanese investors that we work with, prefer to set up a private company because it's just easier to manage, and there's lesser directors you need to appoint, and it's usually more efficient when you're starting a new business. I think I've covered the minimum number of shareholders and directors already. I think one point which we do stress when we speak to foreign investors is you must be very clear what is the type of business you want to do in India. And the reason for that is when you incorporate a company and when you bring in foreign direct investment in India, the regulators require you to identify the type of business you have as per what is called the National Industrial Classification Code. So essentially, you need to fit your business into one of those NIC codes, and it's basis that banks as well as the Reserve Bank of India will identify whether the business you want to do is regulated in terms of India's FDI policy, prohibited, or allowed. And even if it's allowed, as we'll cover later, there are different aspects that you may need to keep in mind in terms of what stake you can hold, what conditions you need to comply with. So it's very important that please identify that, your business upfront to whoever your advisors are when you're looking to incorporate in India. The other thing is to understand what are the basic constitutional documents when you're setting up a company. The 2 basic ones that your advisor will perhaps share with you are the Memorandum of Association and the Articles of Association. The Memorandum of Association is important for you as investors to look at because that will have certain key clauses or key guidelines for the company, such as what will be the authorized share capital of the company, how much of that authorized share capital will be paid up when we incorporate, whether it will be a company of limited liability, which in 99.9% of the cases it will be that, where will the registered office of the company be. So that's all really important because it needs to be specified there. Your articles of association are far more detailed document, and foreign investors will need to look at that from the perspective of corporate governance, such as how your board of directors, how meetings will be held for board of directors, how your shareholder meetings will be held, what are the quorum requirements. Sometimes, for example, if a Japanese investor is looking to enter into India through a joint venture with an Indian partner, it's very important that whatever terms you have in terms of corporate governance, or let's say you've contractually agreed in a shareholders or joint venture agreement that there are certain business decisions which will not be taken without the prior consent of the Japanese investor. Indian law, in fact, there's a series of judgments which, and there's a practice that's developed that those terms to be enforceable against the company should ideally be incorporated into your articles of association. So you need to make sure that you do that as a matter of practice. That's not a very ordinary practice outside India, and those I think should be kept in mind when you're looking at your articles of association. Unfortunately, what we've seen, what tends to happen is sometimes foreign investors will use an individual practitioner and they will give a standard form of the memorandum and articles of association. But a lot of the times the standard form that the Companies Act provides does not empower the company to do very basic corporate actions such as buyback of their securities, issuance of convertible securities, issues of debentures. And then it becomes a headache later because you could have done that when you incorporated, but then when you want to do that corporate action, you're having to go through the entire corporate process of amending your articles of association to allow your company to take those corporate actions. So I briefly covered things that I think at least at the outset should be kept in mind from an Indian Companies Act perspective. I'll just spend 2 more minutes on why we need to think about Indian foreign exchange regulations as a foreign investor. So one is that there are different routes to enter India as a foreign investor. But the most common is FDI, or foreign direct investment, which is supposed to be a semblance of lasting equity stake in the company. Of course, investors can also invest in the stock markets and listed companies through the foreign portfolio investor route. They can also invest in debt in Indian companies. But right now we're looking at incorporated company, and therefore FDI is important. FDI is regulated by two documents. One is the Foreign Exchange Management Non-Debt Instrument Rules, which have been notified under FEMA by the Ministry of Finance. It's administered by the Reserve Bank of India. They were refreshed in 2019, and in fact, that's when they were notified. And then you have the Ministry of Commerce and Industry, which issues the FDI policy. Now, a big confusion that sometimes clients have is they think FDI policy is law. That's absolutely wrong. FDI policy is just a statement of intent and policy. It actually, while there are press notes that the DPIIT under the Ministry of Commerce issues to amend the FDI policy, technically the FDI policy itself says that it doesn't take effect until the Ministry of Finance amends the non-debt instrument rules. So we've had situations, for example, when we've acted for Japanese investors when insurance was 26%, FDI went to 49. We had insurance JV partners being Japanese who said, well, the FDI policy has been amended, why can't we increase our stake? The reason for that is because at that point of time, the regulations or the rules nowadays weren't amended. So you have to wait for that. Now, when we're looking at FDI, the way you have to approach it, I have about 2 minutes left, so just very quickly, is there are certain types of business activities where FDI is not allowed. Examples of that would be lottery, gambling. Apart from that, then how the FDI policy or non-debt instrument rules is you need to basically identify where your business fits under which head. For example, is it media broadcasting? Is it financial services? Is it construction and development? And under that head, there will usually be a stipulation that there's a certain amount of ownership you can have in that company. So it can be usually 26%, 49%, 74%, and 100%, right? Apart from that, the policy will prescribe certain conditionalities. So for example, it may say, well, if you're going to invest in financial services companies, there needs to be a minimum amount of cash you put into the company. If you're not putting in that minimum amount, please don't invest in this sector. For example, in the insurance sector, a sectoral condition that the FDI policy says is you still need to apply through the insurance regulator in India and get their approval if it crosses any thresholds that the Insurance Act or regulations require, right? So you need to look at what is my business, what is the threshold in ownership, what are the conditions I need to comply with. Next, there are things called pricing guidelines and valuation reports. So essentially, if you're a foreign investor, before you invest in a company or set up even a company, you'll need a valuation from a chartered accountant or a SEBI registered merchant banker confirming what is the fair market value. And as a foreign investor, the amount of capital you bring in has to be at least above that. So that becomes a floor to how much you bring in. Because obviously, the Reserve Bank of India wants to encourage more foreign inflow into India, and that's how it works. There's also reporting requirements. I'll not go into a lot of them, but essentially depending on whether you acquire fresh shares issued by a company or you acquire shares which were already issued by an Indian or an NRI or another foreigner, different reporting requirements will apply. Both are post facto, whether they're 30 days or 60 days, as it's there on the slide. But that will essentially determine what sort of reporting you need to do. And we should keep in mind, and I'll end on this note because I think I've crossed my time limit, that if you don't comply with foreign exchange regulations, the Reserve Bank of India has the power under Section 13 of the Foreign Exchange Management Act to impose a penalty that is, if not quantifiable, 3 times the amount involved or 2 lakhs. So theoretically, there's a lot of liability if you don't do reporting, you invest maybe incorrectly in a sector. So the key thing is, please keep all of these things in mind if you're looking to invest in India as a foreign investor, and just make sure that you speak to the right sort of set of advisors who can guide you through this. It's not as easy as it seems, but it's also not impossible because I think as of the last statistics, Japan was the 10th highest in terms of FDI in India. So there is definitely a lot of involvement and FDI that comes from Japan. And with that, I'd like to end. As I said, if you have questions for Sushant and I, we'll be available during the coffee break. Please feel free to reach out to us. We'd be happy to.
Thank you, Mr. Rohan. Thank you, Mr. Sushant. And before you go, we would like to felicitate. And to felicitate, we would like to call Mr. Prashant over here.